My name's Jean Back. I hope that people can hear me and that it's not cutting in and out. If it is, I'd really appreciate you letting us know so that we can fix the technical difficulties. I'm sure apologize for that. My name's Jean Back. I'm an Oregon lawyer, also licensed to practice in Washington. Today I'm going to be presenting on the new overtime regulations and other FLSA issues. I decided I really wanted to give you all sort of a refresher on the regular FLSA issues so that we could, you could be sort of up to speed by the time we start talking about the new regs. One thing I'm going to ask everyone to do, if you're on a phone, if you could mute your phone on your end so that we're not all hearing what's going on in your office, that would really help out, I think, on the audio. So today, what we're going to cover is a refresher on the basics. I'm going to talk to you a little bit about the regular rate, bonuses, and overtime. We're going to talk about exempt versus non-exempt employees and the new DOL regulations. And then I'm going to talk and give you some information about how to prepare for implementation of the new rules. I did get a number of questions from the audience prior to the webinar starting. I got so many that I'm not going to be able to answer most of them today. And I will try to get back with you by email if you would like, and I can give you some answers to your questions there. Some of them I'm going to hit on just to give, yes, like nonprofit information or school information. So hold on there and we'll get to that. Okay, so first let's talk about the overtime, regular rate, and bonuses. So just very simplistic, because I didn't know how much the audience really knew about the Fair Labor Standards Act. I know there are a number of HR folks that are going to be more sophisticated, and I think there are a number of other folks on the line that may not be as sophisticated. So we're going to talk a little more simplistically here, and I apologize if it's too simplistic for you. So overtime pay, covered non-exempt employees must receive 1.5 times their regular rate for all hours worked over 40 in a work week. That is the general rule. We're going to break that rule down and talk about each of these sort of meaningful words that's within that sentence. So first, we're going to talk about a work week. A work week, basically, compliance with the overtime provisions is determined by a work week, and every employer can set their own work week. Each work week stands on its own, so you don't look back to a prior work week or ahead to a future work week. You look at the work week that you're dealing with for determination of overtime pay. A work week can begin any hour and any day, but must be 7 consecutive 24-hour periods, so 168 hours. So you can have it start and end whenever you want. You should make it clear to your employees, though, when it's going to start and when it's going to end. And usually that's something that we set out in an employment manual. So you can establish different work weeks for different groups of employees. And that may be something that works for you if you have employees that do different kinds of jobs or where that makes sense. The one real important rule is that your employees need to know which work week applies to them. So you just need to make it very clear to them what the work week is that they're dealing with. Okay, so we're going to talk about the hours that are included. Any hour over 40 hours in the work week is going to be considered overtime. Only hours worked count to determine overtime hours. So hours that they don't work don't count to determine overtime hours. There are many times where you pay an employee for time, but they don't work. So for instance, holidays, vacations, sick leave, absences due to voting, jury service, inclement weather, or funerals. So those are all times when you may be paying an employee out of a PTO policy or a holiday benefit that you might have, a vacation benefit, a sick leave benefit, whatever. But that doesn't count towards the 40 hours that an employee that you have to pay overtime on. So for example, you might pay an employee for 48 hours. They may have worked 40 regular hours, say they worked 40 hours between Monday and Thursday, and then they took Friday off. And so they will have worked 48 hours in that week, but you're not going to pay them for the hours that they took off. That 8 hours isn't going to be counted as part of the 40 hours for purposes of overtime. You will have paid them for 48 hours, but for purposes of overtime, you're only really looking at 40, because that pay that where they didn't work is not included in determining overtime. Okay, regular rate is another word that was in that sentence that was full of very important words. The regular rate is the hourly rate that you use to determine overtime pay. It is determined by dividing the total earnings in the work week by the total number of hours worked in the work week, and it may not be less than the applicable minimum wage. We're going to talk a little bit more about regular rate as we move on in the seminar. So, regular rate inclusions, these are amounts that you pay that are included in the regular rate. So, on-call pay is pay that would be included in determining what the regular rate is. Shift differential, weekend differential, longevity pay, commission payments. And then this bottom one may be confusing to some of you, and I'm going to try to explain it in more detail here. But you see the word bonuses up there in the little graphic that I have, and the bottom part talks about that. Safety, incentive, productivity, attendance, and merit bonuses can all be included in the regular rate if they're non-discretionary bonuses. Non-discretionary bonuses are defined by the Fair Labor Standards Act, and that is when the time of payment is promised, the amount of payment is promised, and the fact of payment is promised. So it's a bit like a contract. You don't have discretion over paying it. Okay, now we're going to talk about items that are not included in the regular rate. So some's paid as gifts. Payments for time not worked. That's that sick time, vacation pay, holiday pay example. Reimbursement for expenses. Discretionary bonuses, bonuses that you have complete discretion over paying. In other words, there's no contract to pay those bonuses. You haven't promised to pay them. It's just they might get it if they do good work. Profit sharing plans, retirement and insurance plans, overtime premium payments, and stock options. Okay, so compensation included. This is the compensation that you would include in the regular rate. Wages, salary, and that could be salary, hourly, piece rate. And when I talk about salary, I'm talking about people that may be paid on a salary basis, but they're not exempt employees. Okay, commissions, certain non-discretionary bonuses. We're going to talk more about that. Tips, reasonable cost of room, board, and other facilities provided by the employer for the employee's benefit. Okay, I promised more on non-discretionary bonuses, and here it is. Bonuses must be included in the regular rate, as we've talked about, for determining compensation unless there's no promise to pay the bonuses. Alternatively, if you've promised to pay it, then it has to be included. The employer has sole discretion over the amount of the bonus. If you've promised to pay a certain amount at a certain time, for instance, if you make 40 widgets in an hour, maybe that's what's expected. Anything over 40 widgets, you will get 5 cents a widget as a bonus for making over 40 widgets. Then that is an amount, a specific amount that you've promised, and it's not discretionary, okay? And the employer has the sole discretion over payment of the bonus. You don't have sole discretion over payment of that widget idea because you've already promised that you will pay them 5 cents for every widget that they created over 40 widgets. Now, this also comes into play for safety bonuses. In other words, if you don't have any workers' comp injuries, we will pay you a bonus at such and such a time and such an amount. That is a non-discretionary bonus that has to be included in the regular rate. Now, here's the tricky part, and here's the part that a lot of my clients get really caught up on. If you end up paying a non-discretionary bonus that's included in the regular rate, you do have to go back for the year and recalculate what the regular rate is. You won't have paid that bonus until the end of the year, but it has to be included in the regular rate for payment of overtime over the whole year. You may have paid over, so if, I'm just using an example that maybe you had a bonus that was a safety incentive bonus or an attendance bonus that you didn't pay until the end of the year. Whenever you pay it, this is just my example. So say you have this bonus that you weren't going to pay until the end of the year, and you gave them a certain amount of money, but you paid overtime in January, February, March. You will have to go back and recalculate the regular rate and figure out, because they get time and a half of the regular rate of pay for their overtime rate. It's likely, in fact, it is the case that you're going to owe them more overtime based on the fact that you have a new regular rate with that bonus included. I had somebody ask me a question about whether you could then cut up the bonus and pay a bonus in June and a bonus in December. How would that change things? It would just mean that you would have to recalculate the regular rate for January through June and pay any extra overtime that you might owe based on that new regular rate, which is going to be higher than their old regular rate. If you have any questions about non-discretionary bonuses, this is covered pretty well in the Fair Labor Standards Act regulations, and you can go to those regulations and read about it. Okay, now we're going to talk about discretionary bonuses. Discretionary bonuses are bonuses where the employer retains discretion about whether the bonus is going to be paid, the amount of the bonus, when the bonus is going to be paid, and there can't be any promise or agreement or contract to pay the bonus. In that case, it's a discretionary bonus, and it's a bonus that is not included in the regular rate. So bonuses that are announced to employees, as I've mentioned, to induce them to work more steadily, more rapidly, or more efficiently are regarded as part of the regular rate because those are non-discretionary bonuses. Okay, the Fair Labor Standards Act does not require that you pay vacation pay, holiday pay, that you provide severance pay or sick pay, or any of the other things that are listed on these slides. Meal and rest periods aren't dictated by the federal Fair Labor Standards Act. Premium pay for weekend or holiday work isn't required. Any sort of discharge notice or notice regarding whether somebody's going to be discharged or notice if somebody's pay is going to change isn't required. You're not required to provide payment at any time period for the payment of final wages. And there's no limit on the number of hours or days in a week that an employee at least 16 years old may be required to scheduled to work. And there's no requirement for pay raises or fringe benefits. Now, please note that all of these things can and probably are in most states covered by state law. So vacation pay isn't covered in Oregon law, neither is holiday pay or severance pay, but sick leave pay is. In Oregon, we have a statute that makes it mandatory to pay sick leave for at least 40 hours a year. So for certain employers. And if you are required to pay sick leave in your state or in your ordinance, where by ordinance in your county or local jurisdiction where you work, that's probably something that you already know. Or if you have a question about that, you should definitely ask whoever your legal counsel is, or you can probably Google it for your state and find out that information. Okay, we're going to get into talking about the exemptions now. We call these white-collar exemptions because they're normally people that are in the management type field or education type field where you've got an advanced degree or something like that. So these are people that are not blue-collar workers, meaning that they do a lot of work on the production line or a lot of manual labor. So they're also called 541 exemptions because 541 is the section of the regulations that covers these exemptions. So it's 29 CFR Section 541. So white-collar exemptions applies to certain executive employees, administrative employees, professional employees, outside sales employees, and computer employees. And keep in mind, we're talking about the federal law here. I'm not talking about your state-specific law. And some states have different rules on the white-collar exemptions. I know Oregon has different rules with respect to outside sales. So do refer to your state rules to fill in the blanks here. But for exempt and non-exempt employees, that's what we're talking about now, to be exempt from overtime pay, that is, to not be covered by the Fair Labor Standards Act such that you have to pay minimum wage and overtime, there are two broad requirements. First, the person has to work in a qualifying job, and they have to have certain exempt duties that they actually perform, not that they're just contracted to perform. Second, they have to earn a certain salary. Now, keep in mind that the salary basis part of this doesn't apply to some to doctors or lawyers, to some teachers or outside sales. I did get a number of questions on teachers, and I will cover those a little later in the presentation. I'll try and get to those for you. Computer employees also the salary basis doesn't apply to them as long as they're paid $27.63 an hour. But if they don't meet both of these tests, that is the duties test and the salaries test, they're non-exempt and they must be paid overtime. So now we're going to talk a little bit about the salary test, and that's the test that was affected by the new DOL regs, and we'll get into that in a little bit. But specifically with respect to the salary test, this means that an employee has to regularly receive a predetermined amount of compensation each pay period on a weekly or less frequent basis. So each pay period, they have to get a regular amount. The compensation can't be reduced because of variations in the quality or quantity of work. So if they did a really bad job and you're disciplining them for something, we'll talk about the discipline issue. There could be an exception on that. But if they just did a bad job and say you're not disciplining them because they violated something in a written policy provision in your manual, then you can't, that's quality of work, and you can't dock them pay because of it. You also can't dock them pay because they didn't work 40 hours in the week or they worked less hours than you might want them to. If they're truly an exempt employee, exempt from the Fair Labor Standards Act, then you have to pay them the same amount every week regardless of those two things. And they also have to be paid a full salary for any week in which they perform any work. So if they even work for an hour, then you have to pay them the full salary. They don't need to be paid, however, for weeks in which they perform no work whatsoever. But this kind of begs the question, if you have an employee that is off, not performing any work because they're on vacation, so you might not pay them a salary because they're on vacation. You might pay them out of some other pot, like a PTO pot or a vacation leave pot. But if you don't provide vacation leave and they didn't work any hours, then you wouldn't have to provide them any money unless they reviewed an email or took a phone call or did any amount of work whatsoever. And then you would have to provide them their full salary. There are certain exceptions from this pay docking rule, and there are exactly 7 of them. So we'll go through them. Absence from work for 1 or more full days for personal reasons other than sickness or disability. So if they're absent from work and it's for a full day and they perform no work in that day, then you don't have to pay them other than for sickness or disability. So absence for work for 1 or more full days due to sickness or disabilities if the deductions made under a bona fide plan, policy, or practice for providing wage replacement. So you do have to pay them if they're sick or disabled, you have to pay them their salary unless you have some pot of money that's replacing the salary, and it has to be a bona fide pot of money, like a PTO policy or a sick leave policy or something like that. So you're still paying them the same amount, right? Whether it's called salary or whether it's called salary plus PTO, they're going to get the same amount of money. It's just coming from a salary pot or a PTO pot, and I hope that makes sense to you. You can also deduct monies to offset any amounts received as payment for jury fees, witness fees, or military pay that the employee actually gets. So again, they get the same exact amount of money. We're just talking about which pot it comes from, okay? I hope that makes sense. Okay, more rules from the pay docking rule. Penalties imposed for good faith reporting or for good faith for violating safety rules of a major significance. So if they failed to lock out a machine, that's a safety rule of major significance, and you imposed a penalty of $100 or whatever, a monetary penalty, you could dock their pay for that. Also, if you suspended them for 1 or more days because they violated a written workplace rule of conduct, and that has to be written, it should be in your employment manual or some other place where you can show that it's written, then you don't have to put them on paid administrative leave. In that case, they would be on unpaid leave because they're being disciplined for something that they did wrong. Also, a proportionate part of the employee's full salary may be paid for any time actually worked in the first and last weeks of employment. So what that means is that if the employee starts work and doesn't work the full week, and this is in their first week of employment, you don't have to pay them for the full week because they didn't work for the full week and they weren't even your employee at that time. Likewise, when you terminate an employee, they stop becoming your employee, then you're no longer required to pay them, even if it's midweek. Okay, so the first and last weeks of employment, if they start in the middle or end in the middle of the week, then you don't have to pay them for the full week. Unpaid leave taken pursuant to the FMLA, the Family Medical Leave Act. So you're not required to pay them their salary for that. Now, you may be required to pay them sick leave based on a state sick leave law that requires payment of sick leave. But at least with respect to their salary, you're not required to pay their salary when they're on unpaid leave. Okay, so what happens if you screw up and you accidentally deduct money from their salary and you shouldn't have? If you do that, that can result in the loss of their exemption from the Fair Labor Standards Act, and they can become a salaried worker. And this would happen during the time period in which the improper deduction was made, and for the employees also in the same job classification, because I guess the way the DOL looks at this, if you made the mistake for one employee, you probably have made it for others. And also working for the same manager responsible for the actual improper deductions. However, isolated or inadvertent improper deductions are not going to result in the loss of the exempt status if you reimburse the employee as soon as you figure out that you made an improper deduction. There is a safe harbor. I don't think all employers have everything in play to be able to take advantage of this safe harbor, but if the exemption will not be lost if you have clearly communicated your policy prohibiting improper deductions and including a complaint mechanism. So both, you have to have communicated it and you have to have a complaint mechanism. If you reimburse the employees for any improper deduction that's made, and if you make a good faith commitment to comply in the future, then you won't turn them into an hourly employee, unless you willfully violate the policy by continuing to make improper deductions after receiving employee complaints. Okay, so we're going to move here into the actual exemptions. So now we're talking about the duties test for an executive exemption. So for an executive exemption, the primary duty has to be the management of the enterprise or of a customarily recognized department or subdivision. So that could be the CEO is an executive, obviously. But people who manage departments under the CEO can also be executives. And in fact, people that even manage smaller departments within your organization can be exempt if they meet all of the other requirements as an executive. They must customarily and regularly direct or supervise the work of 2 or more other employees. And it has to be more than just being a lead. It has to be somebody that actually has a say or impact on that employee's job. So they have to have authority to hire or fire other employees. Now, if they don't actually have, if the decision to hire or fire doesn't rest with that person, that isn't you don't lose the exemption for that reason. As long as they can make recommendations to somebody about hiring and firing or advancement or promotion of that person. But they have to have a real say in it, and you should make sure. I've had cases on this before, and you need to really set a paper trail for that. So there needs to be something that you can show in writing where that supervisor actually made a written decision or a written recommendation for hiring or firing. If you don't have that, then you're going to get a he said, she said situation at litigation, and you have the burden of proof in that area. So you need to be really careful about that. Okay, also we're looking at the enterprise management. So the Department of Labor, DOL, stands for Department of Labor Regulations. This is the section 541.102. If you wanted to look this up, you could Google 29 CFR section 541.102. This sets out a list of functions that relate to the management of the enterprise. The list contains 25 different management functions, and it includes all levels of employee supervision and management of a facility. Okay, so that was the basics on the executive. The executive is actually a pretty easy one to figure out. I mean, they have to basically fall under those few rules that we set out and have actual management authority there, and then have the ability to impact and supervise the work of 2 or more employees. Now we're going to move into the administrative exemptions, and we're going to talk about administrative duties. And this is office or non-manual work. And quite frankly, this also does apply to executives, because executives are doing manual work. They're not going to, they may not qualify for the executive exemption. But for the administrative exemption, this is primarily what we look at. And we look at the primary duty. That's the main duty, more than 50% of the time. Whether that has to be performance of office or non-manual work directly related to the management or general business operations of the employer or of the employer's customers. So the primary duty has to include the exercise of discretion and independent judgment with respect to matters of significance. So what are we talking about, management or general business operations? For the administrative exemption, generally, if a person is working in one of these areas, then they're working in the area of management or general business operations. And I'm not going to read through all of these for you because you can read them, but it's all the things that you would think about that are more of an administrative kind of level of work. Advertising is included in it, marketing, research, human resources, legal and regulatory compliance. So all of these types of areas. So we're going to talk a little bit about the production management dichotomy, because this is something that was a big part of deciding whether somebody met the administrative exemption, especially when you when you ended up, unfortunately, having a case that went to court. So what exactly is this? It's a phrase that originated from the DOL regulations, but is used by the courts to describe the difference between production work, that is line work, where you're actually doing the manual work of the employer, and work that relates to management and general business operations, which was the slide that we just looked at. So the DOL regulation states, the phrase directly related to management or general business operations refers to the type of work performed by the employee. To meet this requirement, an employee must perform work directly related to assisting with the running or servicing of the business, as distinguished, for example, from working on a manufacturing production line or selling a product in a retail or service establishment. So the dichotomy was widely used by the courts prior to 2003. In 2003, there were regulations that were proposed that offered to reduce the importance of this production worker problem. But quite frankly, the final regs didn't really change the rule. So even though the rules set out to kind of affect that, it really didn't. And although DOL has indicated that the dichotomy is not dispositive, it's still really important, and courts still really look at it. So it's something that you need to be, well aware of. And employers have to be careful to ensure that salaried employees are not squarely performing production work. Again, you can lose the exemption if that happens. So now we're going to move into the important term discretion and independent judgment. And that, again, if you want to look it up, if you're one of those people that likes to read the regs, you're going to go to 29 CFR section 541.202B. That sets out 10 different factors. They're all listed here on this slide. Authority to formulate, affect, interpret, or implement management policies and operating practices. Carrying out major assignments and conducting business operations. Performing work that affects the business operations to a substantial degree, even if only related to a segment of the business. Having authority to commit the employer in matters that have significant financial impact. Having authority, or you have authority to waive or deviate from established policies and procedures without prior approval. You have authority to negotiate and bind the company on significant matters. That's, making bids and bidding out work. Providing consultation or expert advice to management. Involved in planning long or short-term business objectives. So strategizing on what you're going to do in the future. Investigating and resolving matters of significance on behalf of management, and handling complaints, arbitrating disputes, or resolving grievances. So those 10 things are pretty important, because generally if an employee meets at least 2 of those 10 things, then they are considered to exercise discretion and independent judgment. So here's what I like to do for my clients. I like to, when they ask me to help them prepare job descriptions, I like to take these 10 things and include at least 2 of them in the job description for a person who has an administrative exemption. And now that's not going to totally insulate you from an argument that the person isn't actually performing that work. They actually have to be performing that work. But it certainly is evidence that that position should be exempt under the administrative exemption if, to start out with, you intended that they would be performing at least 2 or more of these activities. Okay, more on discretion and independent judgment. So the phrase suggests that the employee has the authority to make decisions free from the direction and control of another person. But the fact that an employee's decisions are revised or even reversed after review doesn't mean that the employee is not exercising independent judgment. In other words, the buck stops on the CEO's desk, and that doesn't mean that anyone below the CEO, that the CEO or or the COO or whoever it is that might review those things has a decision to look at and make a different decision on, doesn't mean that they're going to fall under the administrative exemption. They did have the authority to make those recommendations, and the fact that they're revised or reviewed doesn't really matter. Okay, we're going to move into professional duties. So the primary duty for a professionally exempt employee is the performance of work requiring knowledge of an advanced type in a field of science, learning, customarily acquired by a prolonged course of specialized intellectual instruction. And the primary duty is performance of work requiring invention, imagination, originality, or talent. So these are two different prongs, if you will, for the professional duty. Now I'm going to say a little bit here about teachers because teachers are professionals. So bona fide teachers are not subject to the salary level requirement of the white-collar exemption. Teachers are exempt if their primary duty is teaching, tutoring, instructing, or lecturing. And teachers include professors, adjunct professors, and teachers of skilled and semi-skilled trades and occupations. Now, you might ask, well, what about our coaches? Like if you're an institution that hires coaches, athletic coaches and assistant coaches may fall under the exemption if their primary duty is teaching, which may also include instructing athletes on how to perform their sports. If, however, their primary duty is recruiting athletes or doing normal manual labor, then they're not going to be considered exempt in the way that coaches would. So there are different levels of teachers, and depending on where the person falls, especially for a university type organization, falls, then you're going to be looking at something different. So I hope I did answer some questions on that. I know there were other questions on the school district type employees. I think one of them had to do with full year workers. And it's just to let you know the exemption isn't lost in situations where an annual salary covering a duty period of less than a year, where prorated over the full 12 months computes to an amount less than the required minimum, provided that the amount of salary when prorated over the actual duty period meets the required minimum amount. So I know that was a mouthful. I'll tell you that there are fact sheets on the DOL website on all of this. And so if you have more questions about your teachers, I do encourage you to go to the DOL website and look for the fact sheet. They have fact sheets on almost everything, and that is something that you can find a fact sheet on. Okay, I'm going to move forward. So we're talking about the field of science or learning, and occupations that are within the field of science or learning are all of these occupations. So for a professional employee, I am a lawyer, so I'm exempt as a professional employee, and so are all of the other types of people that might fit under these categories that we have listed here. Okay, and then the artistic, the second prong was the artistic prong. So you have your musicians, your writers, your actors, and your graphic artists. And they can all meet the duties tests for the artistic or creative prong. They still have to meet the salary test. Okay, now we're talking about computer-related occupations. And I'm not going to read through all of this verbiage because you can read it. But the primary duty is going to be the applications of systems analysis techniques. It's all of that IT stuff that folks do, or even just consulting users to look at hardware, software problems, designing, documentation, creating modification of computer systems, testing, creation, or modification of computer programs related to machine operating systems, or a combination of any of those that requires the same level of skills. In addition to that, the employee must receive a guaranteed salary or fee of $9.13 per week or more, or an hourly rate of not less than $27.63 an hour. So outside sales, as I mentioned earlier, there are some regulations in different states that treat outside sales differently. So I want to make sure that you have thought about that and review your own state's laws. But with respect to the Fair Labor Standards Act, the overview of this is that the employee has to be employed to make outside sales calls. That's not sitting at their desk and calling outside of the office. That's leaving the office, or actually not even working in an office, just going out and making calls like your Fuller Brush guy, or obtaining orders or contracts for services or use of facilities. They have to regularly contract with customers away from the employer's place of business. And this is kind of a little tricky thing, and that is that their home office is considered your place of business. So they can't be doing it from their home office, making phone calls from their home office. They have to be actually going out to the client's place of business to, or elsewhere outside of the home office to contract and meet with people. So the pitfalls of the outside sales exemption is that the home office is a tricky thing and is considered actually, your place of business. And an employee who manages existing contracts rather than signing up new ones may not apply. And then keep in mind that different states have different rules. For example, in Washington, they can't spend more than 20% of the week doing other non-exempt tasks. So, and they must have the right to control their own hours. So there are different little rules like that in various states that might affect the outside sales exemption. Okay, nonprofits. We did get some questions on this. And so nonprofits, the new DOL regs are not changing how we look at, how the DOL has looked at nonprofits. I think people hoped that it would, because the salary amount is going up to such an extent that it's going to make it very difficult for a lot of nonprofits to be able to pay the new salary amount. So I think a lot of people were hoping that nonprofits would now be exempt, but they're not. And the DOL made that very clear when they brought out the final rule. And if you are a nonprofit and you want to read more about this, there is a fact sheet on it on their website related to the new DOL regulations that goes through the whole thing. But I'm going to summarize it for you here. And that is that certain nonprofits have never been subject to the Fair Labor Standards Act. And if they weren't subject before, they're not going to be subject now. And that is if they're not engaged in commercial activities where they earn at least $500,000, and that is selling products or services that amount to $500,000. Or if and donations don't count in that amount, that $500,000 amount. So you have to be engaged in an, and that was always the coverage test for the Fair Labor Standards Act. But even if your organization, your nonprofit organization, doesn't earn $500,000, so you're not covered, particular employees that you employ may nevertheless be covered by the Fair Labor Standards Act. So either your organization can be covered or a particular employee can be covered. And so if the employee is engaged in working to do something that's engaged in interstate commerce, that is where it crosses state lines, then they are going to be covered by the Fair Labor Standards Act, even though your organization may not. Volunteers are not covered if for public service, religious, or humanitarian objectives. So that's the essential rule on nonprofits. I have some other notes I'm just going to look at here and make sure that I've gotten everything done there. Yep, I have. So I know that's tricky. Again, I encourage you to go onto DOL's website and look at their fact sheet if you continue to have questions. But generally, if you were covered before, you're going to be continued to be covered. All right, what you've all been waiting for, the new DOL regs. So the last update and we call these the 541 exemptions because, again, it's 29 CFR Section 541 that's where these exemptions are covered. The last update to the 541 exemptions was in 2004, and that combined the short test factors with this long test factor. So if you can believe it, it used to even be more complicated to figure out. They did try and simplify it in 2004. The new update doesn't change the duties test at all. It just increases the salary level, okay? So the minimum salary amount is changing to $913 per week, or $47,476 per year. The minimum amount for a highly compensated employee is going to increase to $134,004 annually. Non-discretionary bonus. So this is a huge difference. If you pay non-discretionary bonuses, that's why we went through all of that discussion earlier on about what a non-discretionary bonus was. Those are bonuses where you've promised the amount, you've promised the time of payment, and you've promised the fact of payment to an employee. If you pay non-discretionary bonuses or you provide incentive payments or commissions, you can satisfy up to 10% of the minimum salary requirement, but the bonuses have to be paid at least quarterly. So you essentially have to true up quarterly to make sure that the employee has received the quarterly portion of $47,476. So you know, if you do apply non-discretionary bonuses, incentive payments, and commissions to satisfy 10% of that amount, and say you didn't actually equal 10%, you're going to have to pay the difference. So you just need to make sure and do it. And even though it looks like that's something that's really going to help employers, to me, it sounds like it's a complication that may end up getting some people in wage claims if they're not really careful about, you know, following up and being super careful about figuring out, you know, whether they've met the requirements. So for the new DOL regulations, the impacts of the regulations are going to be significant. Most employers are going to be required to analyze employee classifications and make changes. And it's expected that these changes are going to impact at least 11 million employees. There's going to be an automatic threshold for salary increases, and the salary levels are going to increase every 3 years, beginning on January 1st, 2020. We should know 150 days before that what the salary level is going to be. So there you go. Okay, so we talked about the salary and bonus calculation, and you employers who decide to do that are going to have to pay at least 90% of the minimum salary each work week, and that's going to be $821.70. And at the end of the quarter, the salary plus all the bonuses and or commissions paid during that quarter don't equal at least a quarter of the salary requirement. That's the full year requirement right there. Then the employer must make up the shortfall in the first pay period of the quarter. Again, I would be very careful about how you implement that. It could be very helpful. You just got to make sure you've crossed all your T's and dotted all your I's. Because some employers are going to be required to reclassify employees from salary to hourly, employers that are in that category are going to need to analyze the need to track hours, because before you didn't have to track hours. You didn't care how many hours your exempt employees were working. Now you care. You need to know how many hours they're working because they're entitled to be paid overtime for hours that they work over 40 in a week. This also, another impact of this is going to be a less flexible workplace, because you're going to have employees that don't have the flexibility of coming and going when they want, and that is going to impact employees as well as it's going to impact you. And then the last thing that maybe everyone doesn't always think about is that some employees really there's a lot of pride and sort of ego, if you will, related or equated to being a salaried employee. When they became a salaried employee, that was like a promotion for them. It was a big deal, right? the difference between hourly and salary, because they consider themselves a management employee. And that is something that they took pride in. And a lot of employees are going to feel like their status in the company has been sort of not, kind of demoted, if you will, because now they're being changed from a salaried employee to an hourly employee. So you're going to have to deal with those, those feelings that your employees are going to have. So the effective date of the new regulations is December 1st, 2016. And you need to consider whether in your state, and it varies state to state. Some states have laws, others don't. Oregon and Washington do not have laws. I've listed the laws that I know about, but please check and make sure your state does not have a law that requires that you provide advance notice of a change in salary, because in some cases, your employees may earn less. And we'll talk about why that would be. But it's either going to be a reduction or an increase in pay. And if it is a reduction in pay, you're going to need to let them know 30 days beforehand in Missouri. In California, any change of pay requires a 7-day notice. And in Nevada, New York, and South Carolina, it's 7 days notice before a reduction in pay. Okay, so steps to compliance. What are you going to want to do here? You're going to want to audit your workforce now. It's a great time to do it, and that means really look at what your employees are doing. Are they actually performing the job duties that meet the criteria for an executive or administrative or other type of employee? If you had incorrectly classified employees before, then now is a good time to fix those classification problems without really any problem that the employee is going to come back to you and say, oh, you owe me, overtime for all these, for at least 2 years because you incorrectly classified me. Now you can say, no, I never incorrectly classified you. I'm just having to change things and change your status because of this new law. So it's a perfect time to audit your workers. You want to audit for both salary and duties, and you want to find out how many hours employees on the cusp, that means those employees who are, close to the point where you say it's not worth it for me to increase them to $47,000 an hour, actually work. You want to develop a new compensation plan for the reclassified employees. What are you going to do? You're going to make them hourly? Are you going to use a fluctuating work week? We're going to talk about what that is, but that's for employees whose hours always fluctuate. They don't ever work a work week that's just 40 hours. Are you going to raise their pay to retain the exemption? So those are, your choices here. So if you're going to change a salaried employee to hourly, your options include decreasing the hourly rate and allowing them to work overtime to catch up to their prior salary amount. Now, I hope you follow that. If you just took your current employee at their current salary and you divided that by 52 weeks, and you said, and then you divided that, that will give you a weekly amount, and then you divided that by 40, that would give you, or divide the weekly amount by 8 and divide by 8 by 40, how to figure out what the hourly amount is, you'll get your hourly amount. If you're just getting your hourly amount from the salaried amount that they paid, that you were paying them, then you are going to paying them more moving forward because they're going to get time and a half for working overtime. If you want to pay them what they were getting, you don't want to give them any increase as a result of this new rule, then you're going to have to decrease their hourly rate and figure out, allow them to catch up to their prior salary by working overtime. So I hope that makes sense. Your other choice is to compute their new hourly amount based on their former salary and just allow them to work some overtime. So they're going to get paid more because they're going to get paid time and a half for hours over 40 in a week, whereas they didn't get paid that before. Or you're going to compute their new hourly amount based on the former salary and just lessen their workload don't allow them to work overtime. That means you're really going to be having to monitor them. And we did get a question about whether looking at emails and taking telephone calls would be counted. And the answer is yes, that is counted. So if you have employees who used to be salaried employees, they're used to working and not, tracking it, and now they're taking phone calls off work and doing stuff like that, you're really going to have to make a decision about whether you want them to do that. I mean, there may be some employees that you have no choice. Their job is of such a nature that they need to do that. You need to allow them to take those calls. You're just going to be paying them more. But you just really need to figure out whether you can tell them you're not allowed to work overtime. If you do that, and you tell employees they're not allowed to work overtime, you may find you don't have enough people to do the job that used to be done by 1 or 2 employees because they're now only working 40 hours a week, whereas they used to work 50. You may have to hire new hourly employees to help with the load. Okay, computing the new hourly rate. This is the DOL approved method. And that is just taking their weekly salary, dividing it by 40 hours in the week, and anything over that is overtime, which they're paid time and a half of that salary. So the DOL has said that is an approved method that, would be fine. We're going to talk about the fluctuating work week, and it's only for certain types of employees. So you have to be very careful about it. And I would go to the extent of even contacting your legal counsel if you have it, or reading up on the CFR, which is listed here. The fluctuating workweek method of payment permits employers to pay non-exempt employees a fixed salary, even if their hours fluctuate from one week to the next. So someone who would be an hourly employee, you can pay them a salary, even if they're going to work over 40 hours a week or under 40 hours a week from one week to the next. The rule permits you to pay employees overtime at an additional 1/2 of the regular rate. So let me try to explain why this works this way. Say you have an employee and he's worked 40 hours in 1 week, and he worked 30 hours the week before, but he got paid the same amount. You didn't reduce his pay because he worked 30 hours that week, okay? So he's gotten a little benefit right there because he got paid for working at least 40 hours a week. The next week, he worked 45 hours a week. So he's not going to get any more salary from working that 45 hours a week, but because he's working overtime that week, more than 40 hours, you have to pay them 1/2 of their regular rate. You don't have to pay them time and a half because they've already gotten the time in their salary. You only have to pay them the 1/2 of their regular rate of pay for that 5 hours that they worked overtime. That's the fluctuating work week method of paying. Here are the rules that go along with that. An employee must be paid a salary, which is a fixed amount regardless of how many hours they work in any given week. The employee and the employer must have a clear mutual understanding that the fixed salary is compensation for all hours worked in any week, regardless of how many hours are worked in any given week. The weekly salary must be large enough that their hourly rate never falls below minimum wage, even when they work 45 hours a week or 50 hours a week, okay? Because if they work 50 hours a week, so you have to take the most hours that they're going to work in any week and divide that by however many hours it is, 50, 55, and figure out, are they getting at least minimum wage? And the employee's hours must fluctuate from week to week. You can't do this with an employee that works just on a 40-hour week all the time. If you're going to do this, please take these 4 things and write a little agreement and have your employees sign it so that they agree to be paid on a fluctuating work week, and they agree to all of the things. They agree that their hours fluctuate from one week to the next. They have a clear understanding that they're going to be paid a salary no matter how many hours they work, whether it's 50 or 30, and that they're going to get paid half time for the hours that they work over 40. Okay, the next thing you need to do is you need to communicate the changes to your workforce. So this means meeting with your managers, or only the managers of your reclassified employees. If you haven't reclassified anyone, then you don't need to do anything. But if you have reclassified employees, you need to meet with managers to let them know what's going on, because they're going to be the first people that the employees complain to. You need to meet with the employees and explain the changes that you made. You need to decide who's going to present this to the employees. What is that person going to say, and how and when is this going to occur? And you want to consider preparing FAQs for the employees so that they can, if they have questions, or if they go home and try to explain it to their spouse and their spouse says, wait a minute, I don't understand that, or whatever, they can go to an FAQ that maybe exists on their website, or maybe you handed it out FAQs to them at the time that you explained it to them, but this needs to be done. And then further, as a result of implementing your rules, you need to check your policies and practices, and you need to look at what are your policies and practices for flexible schedules, for working overtime? Are you going to allow it anymore? For working off the clock and after time or after hours use of email, how are you going to control that? For telecommuting and travel policies, and we haven't discussed at all the whole travel time pay and basically compensable versus non-compensable pay in a lot of different areas, because that would have been a much longer presentation. But you do have to know that there are rules on these issues, and also for attending trainings and all of those types of issues that deal with compensable pay. It's a bigger topic than we covered with just the bonuses. You also need to bolster training. So you need to train the HR and the managers should be trained. And you shouldn't just circulate a memo that explains all of this. You could, but you also want to train in addition to the memo. And as long as you're training, you might just consider incorporating this into a fuller management training that might also cover other areas that you might want to train on, like leave laws, or there are lots of areas that we train managers on, but you just might decide to make it a longer training and include this in that, if that works for you. And then you want to train the affected employees, so the new hourly employees, so the ones that you chose not to keep salaried but to make hourly employees. They need to understand the rest and meal break policies now apply to them. It didn't apply to them before. Now they have to track their time. In most states, I won't speak for every state, but most states have laws that require that you pay for rest and meal breaks. And so you at least need, or at least that you provide rest and meal breaks, whether they're paid or not. You need to figure that out, and you need to let them know that they need to track that time, and you need to have a way of tracking it as well. Clocking in and out, you need to figure out how are you going to figure out when they're at work and when they're not at work. Overtime permission, activities that are compensable and activities that aren't compensable, and other policies that affect your hourly employees in the same way that you would train any of your hourly employees. Okay, we're almost done, but I heard that Congress might invalidate the new rules. And there were a couple of laws that kind of came to my attention when I was researching this, and one of it is this Protecting Workplace Advancement and Opportunity Act, which was introduced on March 17, 2016. This would effectually nullify the rules and require better economic analysis and prohibit automatic salary increases and changes to the duties test without notice or comment. It doesn't mean that a change, even if this were passed and the president didn't veto it, it wouldn't mean that there wouldn't be a change. It would just, all they want is they feel like the economic analysis that was done didn't adequately show how this was going to affect most employers, and they felt like a better economic analysis was required. Even if this passed, it would be vetoed by President Obama, so it's really not likely to be something that is going to save the day before December 1st. And then there's also the Congressional Review Act, which requires a joint resolution of Congress within 60 days of the publication of the final rule. And again, President Obama would likely veto any Congressional Review Act that came out and invalidated the rules, because this is something that I think he's felt has been due for some time. So that is essentially the materials that I have. There were questions, and what time we have here? We're actually over, but we're over because we had some technical difficulties at the beginning of this program. I'm happy to go through the questions or some of them with you. I tried to cover some of the teacher ones that came in. We had one asking whether the OT rules would impact churches as well as churches with state licensed Christian preschools. And my response to that is that in general, churches are going to be impacted in a couple of different ways by these regs, and it depends on precisely who they employ. If they have bona fide volunteers that are at a religious organization and they volunteer at the church and they don't get compensation or receipt of compensation, then those people are going to be exempt unless they're volunteering in commercial activities like running the gift shop. So that would fall under that nonprofit category. In addition, persons such as nuns and monks, priests, lay brothers, ministers, deacons, and other members of religious orders who serve pursuant to their religious obligations in schools, hospitals, and other institutions operated by their church are not considered to be employees and are therefore exempt. And with respect to preschool and kindergarten teachers, they may also qualify for exemptions under the same conditions as teachers in elementary and secondary schools. There is a fact sheet, it's fact sheet number 46, that covers that issue. And I don't really think we have time to go through every one of these questions that I got, and I don't see any questions that are teed up in the chat box. I've been looking there and I see none. So I assume that there were no questions. You there, Eric?
Can you go ahead and hear? Yeah, can you hear me now?
I can hear you now. Mm-hmm.
Okay, good. I mean, if you've got a little time, we did have a few that came in.
I have time.
Oh, yeah.
Yeah,
so
no problem.
I'll just run through a couple of them while we're here. What about if employees have a work week of 35 hours, how do we calculate?
Okay, so if an employee has a work week of 35 hours, then so you pay them a salary. I mean, it's, I guess I'm wondering, is this employee going to be an exempt employee? They just have a 35-hour work week? See, some of these questions you just can't answer without following up with a question. But let me just make an assumption here that this is going to be an exempt employee and their work week is only 35 hours. I haven't seen anything that says that the $913 per week is affected by the number of hours that an employee, as an exempt employee, works. So I think you're still going to have to pay that exempt employee the weekly rate, which applies whether they work 35 hours or 50 hours for an exempt employee of $913. If they're exempt. If they're non-exempt, it's a totally different question, and you could look at that fluctuating work week form of payment if their work week fluctuates.
Okay. Thanks, and we'll just keep jumping right into them. This question is, would it be ideal to get a letter of opinion for the organization regarding the exemption of the FLSA at nonprofits?
Okay, I don't think so, because there's already a fact sheet on it. The DOL looked at this very carefully when they promulgated the final rule. It was something that was put to them in the comments for the final rule when they were looking at promulgating it, and the decision they made is the decision they made. It's actually discussed in the final rule, and there is a fact sheet on it on the DOL website. So I don't think there's a need to get a DOL opinion letter, because the DOL has made very clear that the exemption is the same as it always was for nonprofits. They just decided they're not going to give nonprofits an exemption, even though it does raise the amount that nonprofits have to pay exempt employees quite a bit. The understanding, I think, is that this is going to hit nonprofits pretty hard, and the DOL didn't seem to, I don't know, it didn't affect their determination.
Okay, yeah, I'm just picking a few, so maybe do one or two more here. Someone has asked for an explanation of what a quote computer employee is. Okay,
so there was a slide on that, and I don't know how to explain it any better than the slide, which I'll go back to it. Oh, there it was. And also, one thing that's really handy, I don't think I mentioned this before, the DOL website has a e-tool that you can go in and use. So you have to go into the web, it's kind of hard to find, you have to go into the website, go into the wage and hour part, and look for employer advisory tools on exemptions. If you go to that, then you'll go through this exercise where they ask you questions and you answer questions, and the end result will be your employee's exempt or your employee's not exempt. And they have one for the executive, administrative, computer, and outside sales. But this is the slide for the computer. The primary duty is, it has to meet basically these criteria, and they have to have a primary duty, meaning working more than 50% of the time, doing systems analysis techniques and procedures, determining hardware, software, or system functional specifications, doing IT type things, modifying, repairing, inputting in computer designs and systems. I don't know how else to describe it. This is how the DOL describes it.
Okay. I'm just seeing a few questions on HCE. I'll run a few of those. One says, how is HCE calculated? Another says, does this mean my HCEs paid less than $134,000 are now no longer exempt and entitled to overtime? So you can calculate.
The answer to the second one is
maybe
yes.
Information about HCE.
The answer to the second HCE question is yes. If you don't pay them $134, it's just the same thing as the salary test. That is, of $47,000. There's always been an HCE salary test. It's been $100,000. Now it's $134. If you don't pay them $134,000, they won't be HCE anymore. Regarding how they calculated it, I don't know the answer to that. The DOL did that when they promulgated the rule, and I don't. It could be buried very deep in the Federal Register on how they calculated it, but I don't know.
Okay, thanks. We'll just do one more here, and then we'll wrap it up. How would a company get in trouble for misclassification aside from an employee demanding back pay?
We talked about that in the presentation. What will happen is that you'll lose the right to the exemption for that employee, and that employee will then become an hourly employee, as well as the other employees who are working in the same department and managed by the same supervisor as that employee. So that's the real problem with misclassifying an employee. And then also, if you misclassify employees, you're subject to a lawsuit by that one employee and potentially a class action lawsuit by other similarly situated employees saying that you didn't pay them overtime correctly, which can be very, very expensive.
Okay, thanks, Jean, for taking those questions. Everybody else who sent a question in either before this or during the webinar, we have your contact and your question. So we'll try to gather all those up and get back to you in some form. Jean, did you have anything else you wanted to say before we move on to the end slides?
Nope, nothing else. I just appreciate everyone's time, and sorry that we had a little hiccup at the beginning. I wasn't even sure if people were actually hearing me in the presentation, but I think we got it fixed.
Yeah, no, I think it was just on my end, so I apologize to everyone for that. If Jean, if you could just flip, you can just flip through the last few slides here. The SHRM credits, the HRCI credits, I sent them out already, but write them down if you came here for those. Jean, you can just go ahead and flip to the next slide. We have some federal resources that we're giving to everyone who attended and signed it up for this webinar at a good price. Write down the coupon code and the URL there, or we'll send you the information after the webinar. And Jean, you can just go ahead and throw it over to the last slide. So yeah, if you, like we said, there was a lot of interest in this webinar. We received a lot of questions. If you want a more immediate response, go ahead and reach out to Jean is probably the best way, and she'll help you as much as she can. If you have any other questions, you can always email me, eric@hrsimple.com. I think that's it. Yeah, I apologize that we're a little slow getting started. I guess that means that you probably didn't hear my intro about Jean, but yeah, she's from Schwabe, Williamson Wyatt out of Oregon, a great firm that we work with. They author the Oregon Human Resources Manual. So check that out if you're in Oregon. Otherwise, check out those federal resources, which I'll send to you after this. Yeah, I think that wraps it up. We'll get back to you. Jean, do you have any final words?
Nope, just thank you for attending.
All right. Yeah, thanks everybody for sticking around too with the difficulties. We really appreciate it. And thank you, Jean. Thank you, Schwabe, Williamson, and Wyatt. For hrsimple.com, this is Eric. Thanks for attending, and we hope you come out again.
Bye-bye.